It's 3 o'clock. I think so. We should start, and they will join in between those who wish to join. Right. So before starting with the session, let's on behalf of Dharm Shastra National University, I welcome Advocate Akshay Goyal sir. Before sir start with the session, I just want to tell about sir. Just a brief introduction about sir. Advocate Akshay Goyal is a practicing advocate in Supreme Court and High Court, and also deals with certain matters in tribunals and takes certain cases of insolvency and bankruptcy also. He runs his own firm in Delhi in the name of AG and Associates Law Firm Delhi. He has done his graduation from Bharati Vidyapeeth Pune and his post-graduation from Indian Law Institute Delhi itself. Sir is also empaneled as one of the international arbitrator in Dubai International Arbitration Center. Mr. Goyal area of expertise are civil laws, criminal laws, insolvency, bankruptcy, arbitration, and his client list includes Times Group, Ola, Liberty Shoes, Xeon Life Sciences. So, sir, on behalf of the university, sir, I wish and I welcome you, and we can have a good interactive session on institution of suit. Sir, please, sir, you may initiate the session. Sir.
Good evening, class, my fellow companions who will join the legal fraternity in near future. So I'll be taking your class on institution of suit. Institution of suit basically is not defined. Suit is not defined anywhere in CPC. A suit is basically a dispute between both the parties, which is initiated before a court of law to get a certain relief. It has three important stages, which, if not followed properly, the suit can be dismissed or rejected by the court of law. The three basic and most important ingredients of a suit is that first you need to know where the proper jurisdiction of suit lies. That is the place of where the suit should be filed. These things are defined under section 15 to 20 of CPC. It provides where a suit should be filed by the advocate when a client comes to him for a relief that, sir, I have been wronged by a certain person and I want you to file a certain suit or a certain civil, I want you to get me a civil remedy. So section 15 of CPC clearly says that the suit should be filed in the court of lowest grade. The lowest grade depends upon place to place and state to state. For example, in Delhi, any matter which is below a value of 3 lakhs has to be filed before a civil judge. And any matter whose subject matter is above 3 lakh is directly filed before a district judge. And also when the subject matter gets over rupees 2 crores, the Delhi High Court has an original jurisdiction to try the civil suit. Thus, in Delhi, the court of lowest grade for matters having value less than 3 lakh is a court of civil judge. Matters having value more than 3 lakhs is a court of district judge. And matters having value more than 2 crores is a court of High Court, where the original jurisdiction lies. Now coming to section 16 of the CPC, it talks about the jurisdiction of where the immovable property lies. In such cases where the dispute is pertaining to an immovable property, section 16 says that the suit should be filed where the immovable property is situated. Immovable property, there are certain judgments also by the Supreme Court which clearly says that the suit should be filed where the immovable property is situated. There are certain agreements nowadays between, like in case of builder-buyer agreements, the place of jurisdiction is defined as a place where the defendant or where the defendant's office is there, or where the parties decide where the place of jurisdiction can be. But there is a judgment by Supreme Court of India in Harish Modi, wherein it clearly says that the suit should lie where the immovable property is situated. The parties cannot decide that where the jurisdiction can lie. The parties can decide the jurisdiction when the case pertains to a movable property or a recovery of suit or any other civil remedy. But where the immovable property is mentioned, the suit has to lie where this immovable property is situated. Now coming to section 17. Section 17 provides for jurisdiction of court in case of immovable property where the suit property is situated within the jurisdiction of different courts. Like for instance, there is a property, if I again take an example of Delhi, if there is a property which lies on the border of Delhi and UP, or Delhi and Haryana. Delhi and Haryana have borders, Delhi and UP have borders. So if in case there might be a situation that that some part of the property also lies in the state of Haryana and some part of the property lies in the state of Delhi. So the suit can lie in either of the courts. You can file the suit in Delhi also, or you can file the suit in Haryana also, where the part of immovable property is situated. These kind of things happens very rarely, but the law has provided a provision which can solve the confusion of a lawyer that where the suit should lie. Now, section 18 provides that the jurisdiction of court where the local limits of courts are uncertain. Now, it is kind of similar to section 17 that when the jurisdiction of courts are uncertain, you can file the case at a certain place where the place where the property lies or where the limit of court is there. Either of the court can decide the case, but it has to mention that this particular court has a jurisdiction that this place lies here and this court has a jurisdiction. The court has to record its observation while issuing notice before to the other party. Now coming to section 19. Section 19 provides that where the case involves compensation, damages, recovery of an amount, or a movable property. It provides where a suit can be filed in case a wrong is done at one place and the wrongdoer resides at another place than that of the victim. CPC also gives a very simple and very easy illustrations. Like A residing in Delhi beats B in Calcutta. B may sue A either in Calcutta or in Delhi because the wrong person, the wrongdoer resides in Calcutta, resides in Delhi, but the cause of action arose in Calcutta. So he can file the case either in Calcutta or in Delhi. There is another section, section 20, which is a very important section because wherever the section 16 to 19 doesn't give you the picture that this is the jurisdiction of a particular place. Section 20 provides that suit are to be filed where the defendant resides or carries on his business, have a branch office where the cause of action has arisen or partly arisen. For example, where A is a tradesman in Calcutta and he carries on a business in Delhi also. So, and he sends his particular material from Calcutta to Varanasi supposedly, and the material is defective, and the person to whom the material was sent in Varanasi has already given the payments to A, the tradesman. So he can either file the suit in Calcutta or in Delhi or in Varanasi also, because these are the places where the cause of action has arisen partly. He can also file the suit in Calcutta or Delhi because the defendant has a business both in Calcutta and in Delhi. So section 20 says that the defendant, where the defendant resides or carries on his business or has a branch office or has some office pertaining to his business. and also where the cause of action has totally arisen or partly arisen. So the example which I gave, in that particular example, the cause of action has arisen in Calcutta also, because the party B, the person who is aggrieved, had given an order to A in Calcutta. He sent a material from B, Delhi, to Varanasi, and the material was received in Varanasi. So the cause of action arose in Calcutta because the order was given in Calcutta. The cause of action arose in Delhi because the material was sent from Delhi. The cause of action arose in Varanasi also because the material was received in Varanasi. So these are the places where the cause of action is partly arisen. So the plaintiff can file a suit in either of these places. And he can file a suit in Calcutta and Delhi also, or Delhi also, because the defendant has his uh, place of business and a branch office also in both Calcutta and in Delhi. So in either of the places, the suit can be filed. These are the places. Once you go through these sections and you know that the place of jurisdiction, which is the place of jurisdiction where the suit should lie, you should file a suit or draft a suit. That the second, which is the second most important thing, that is the drafting of a suit. The drafting of a suit starts with the very go when the you know the jurisdiction of the place where the suit should be filed. The drafting of suit is defined in Order 6, 7 of CPC. Order 6 defines about the pleadings, and Order 7 defines about the plaint, that what exactly should be involved in plaint. If I may be allowed to share the screen.
Yes, sir, you will. A question has come, sir, if you permit, or at this time or at the last. Sir, a question has come from a student, sir. What is cause of action partly arising or cause of action in whole when it arises? What is the difference in that? How you all take up in courts these matters? And with respect to the objection.
Like the example which I told, that A and B are two businessmen. A is a tradesman and B is a person who deals in that particular goods which A trades in. So B gives an order to A, who has an office in Calcutta, and B and A sends that particular good from Calcutta to the place of business of B. So the cause of action partly arises when B has given order to A in Calcutta, and it also partly arises when A sends the material from Calcutta to Varanasi, or where the place of business of B is. So it partly arises in Calcutta also. It partly arises in the place of business of B also. When it comes to wholly arises, it might be when the parties are are carrying on the business at the same place, and they do certain things. They deal in certain things. So the cause of action arises in the cause of action wholly arises in that particular place. So that is called cause of action arising wholly. And when it says that the cause of action is partly arising, it might arise in at one particular place, and it might arise at one particular place. So that is basically is partly arisen at one particular partly arisen, and what is wholly arising. I think I am clear on that, so I may proceed on the other things. If the student has another question on that, I'm ready to answer on that.
If you have anything, you all may ask. So we may proceed.
Is my screen shared? Yeah. Coming to drafting of a suit, I am sharing the illustrative draft of a civil suit it starts
We are
with,
unable to see the screen, sir. Screen is not.
can it now be seen?
Yes, no, presenting.
Is it visible?
Yes, it's visible.
So this is an illustrative draft of a civil suit. When I told you the place of jurisdiction, it starts with in the Court of Civil Judge, Senior Division, District Court. So when you know that where the place of suit should be, you mention it in the title of the suit in the Court of Civil Judge, Senior Division, District Court. This is the most important thing, because the suit, if not filed before the proper place or proper place of jurisdiction where the pecuniary and territorial jurisdiction lies, suit can be rejected at the very go or returned under Order 7, Rule 10. Now you have to mention that what is your subject matter. It is written civil suit number dash of 2021. So it can, you have to know that abbreviation. CS means civil suit. It can be arbitration petition, it can be original miscellaneous petition, it can be a writ petition. So you need to mention this particular thing here. Now comes the in the matter of. This is also important, the parties of suit. After the place of jurisdiction, you should know what are the parties of the suit. ABC plaintiff. The plaintiff is the client of yours who comes to you that sir, this civil wrong has been done to me, and I want a civil remedy from you. So you name his his name and write plaintiff in front of him. Versus the name of the defendant. The name of the defendant is very important. If in case you do not name all the necessary and proper parties in a civil suit, your suit can be dismissed for misjoinder and non-joinder of parties. So you need to focus that what all or who all can be the necessary and proper party in a civil suit against a particular civil remedy which you are filing for. So it can either be the person who has, like in case where a car manufacturer, you file a case against a car manufacturer for civil damages that this car was not properly manufactured. You name the car manufacturer as a party. The proper party to this particular suit is the dealer also from whom you have bought the car. So you need to see that who all can be the necessary and the proper party. Like in suit of partition, if a person comes that I have to file a suit for partition against my family, so you need to see that who all are the legal heirs of a particular person against whom the suit for partition has to be filed. So the defendants will be all the legal heirs, and you need to mention that these are the defendants in the name of party, and if in case it is missed, you have an option to file an application under Order 1 Rule 10 of CPC for impleadment of defendant as they are necessary and proper parties to a particular civil suit. So after finding out that who are the necessary and proper parties, you come to the title of the suit. Suit for recovery, suit for declaration, suit for partition, suit for damages. It depends upon the case to case which comes to you when client comes to you and what civil wrong has been committed against him. Now you start with the who is plaintiff. You need to define that what is the nature of plaintiff. If in case it's a company, you need to mention that it is that the plaintiff is a company registered under Companies Act 2013 and has a place of and has a registered office at that particular address. And like I have mentioned here, that the plaintiff, if it is a natural born person, that the plaintiff is a law-abiding citizen of India and is residing at the address mentioned in the name of parties, The description of the plaintiff is to be provided depending upon the case. The second point is the description of the defendant. You need to mention who all are the defendants in your particular suit and what that particular defendant do or has role in that particular case. You need to mention that like in case that the case is against a particular company and you are making the director of that particular company a party. So you need to mention that defendant number 1 is a company registered under in Companies Act 2013 and has a place of and has a registered office at that particular address. Full stop. Then the defendant number 2 is the director doing taking care of day-to-day activities of the company and is responsible for a particular thing which is involved in this particular case. Then after description of plaintiff and defendant comes the brief facts. You need to mention all the brief facts and all the material facts which you have depending upon the case which you have in hand. It should not be vague and ambiguous. It should be specific. Like the specification would be in a case where the recovery amount, where it is a suit for recovery, that the first would be that the defendant approached plaintiff to sell certain product and he took money from him for selling those particular product. So, and you need to mention all the things like what invoices were issued, if in case a part payment is made, the part that what was the part payment made, how it was made, and whatever the case may be, it should be specific. It should not be vague and ambiguous like the defendant approached the plaintiff to buy a product and the plaintiff agreed to it and gave money to him. You are not mentioning what product the defendant sold to plaintiff. You are not mentioning the amount which was given. You are not mentioning that what was the nature of transaction. So these kind of facts become vague and ambiguous. The specific facts would be that the defendant is selling these particular products. He approached the plaintiff at a on particular date or in particular in a particular month. After that, the plaintiff agreed to buy the products, and he ordered for this amount of product, which were to be delivered in this period of time, and this was the payment which was made by the plaintiff through this mode. This is the invoice which was issued, and depending upon facts to facts. These kind of facts are specific facts, but mentioning that the defendant came to plaintiff to sell a particular product, these are vague facts. So your facts should never be vague and ambiguous. They should always be specific. After mentioning the brief facts of the case, you need to see where the cause of action has arisen. This particular paragraph in a suit is a very necessary paragraph. That the cause of action to file the above mentioned suit arose as per the circumstances and facts which you have in your hand. Like in the example which I am telling you, you will write that the cause of action to file the above mentioned suit firstly arose when the defendant approached the plaintiff to sell XYZ product. It further arose when the plaintiff ordered for XYZ amount to the defendant. It further arose when the plaintiff made an advance payment of XYZ amount. It further arose and it is arising continuously till the day when at the filing of suit. So this is a paragraph which has to be mentioned. Otherwise, your suit, if you have not mentioned the cause of action, your suit can be dismissed or rejected under Order 7 Rule 11. The cause of action is the most important part in the while drafting a suit. That what, when, and where the cause of action has arisen. Now you also need to see that whether your suit which you are filing is within the period of limitation. Period of limitation is defined as per the Limitation Act. It depends upon case to case. Like in case of suit for specific performance, the suit for specific performance can either be filed within 1 year in case where the specific performance is to be done for sale of a particular product, and if it is not done, it has to be filed within a period of 3 years where there is a transaction of immovable properties. In case of suit for recovery, the limitation period is 3 years. The limitation period starts when you raise the demand, and it starts, it never stops. When it's like a train that when the limitation period starts, it never stops until the station has arrived. So the 3 years starts when you have raised the demand, and in case you like, if you raise a demand today, that is 5th of March 2021, the 3 years will start from today and it will end on 5th of March 2024. In case you do not file your suit within the period of limitation, the suit is barred by limitation and it will be dismissed on the ground of limitation itself. You need to see that your suit is within the period of limitation. Now comes the court fees clause. The court fees depends upon the Court Fees Act, and also it depends upon state to state. There is whenever you will become an advocate, you will get a law referencer or law diary. It mentions the chart where the court fees is defined for each and every state. Coming to Delhi, because I am practicing in Delhi, so in Delhi the court fees is defined in the chart up to 4 lakh rupees. For a suit for 4 lakh rupees, the court fees is 6,248 rupees. It depends if the value is less than 4 lakhs, it depends upon the chart. But if in case the value is more than 4 lakh rupees, the court fees is calculated like up to 4 lakh rupees, it is 6,248 plus for every 5,000 you add a 48 rupees and 80 paisa. So in case you have a suit subject matter where the value of the suit is 4 lakh 5,000, so your court fees will be 6,396 rupees and 80 paisa. So you need to calculate according to the chart which are given as per the state to state. It varies in Haryana, it varies in UP, it varies in Madhya Pradesh, where you are studying. It varies in all the states. After this court fees provision, you need to mention that no other similar matter pertaining to the same issue has either been decided or is pending before any other court. If in case it is found out that your suit was earlier decided, you can say that the same issue between the same parties was earlier decided, then the principle of res judicata, which is defined under section 10, will come into picture and your suit will be dismissed then and there at the very first floor. Now, if in case it is found out that a similar suit is pending before any other court on the same particular issue between the same parties, then the suit will be, the res judicata is under section 11, then the suit will be stayed as per section 10 of CPC, that is res sub judice, that the matter is pending before that the matter pertaining to the same issue between the same parties is pending before any other court. So this matter may be stayed vis-a-vis till the final decision in that particular matter is made out. After this particular provision, because this particular provision is very, very much necessary. So after that, the most important clause comes into question. What are your prayers? What exactly you are asking for from the court? You need to see that what exactly the demand is, and you need to mention that as per the above mentioned facts and circumstances, This honorable court may be pleased to pass an order and allow the above mentioned suit and pass a decree whereby directing the defendant to either perform a particular action, to either not perform, either omit or act to do a particular thing, either to injunct him from particular actions, either to declare that this particular property or this particular thing belongs to the plaintiff, either to divide the particular property into the shares of the legal heirs. So it depends upon the facts to facts of your case, and the relief should be very specific that this is what we are asking for. Now comes a very simple clause that any other order which this honorable court may deem fit in the interest of justice. The court may pass any other order which is the subject matter of the suit and has the power under section 151, the inherent power, to pass an order which is in the interest of justice to both the parties or to the plaintiff or to the defendant. After these prayer clause, you need to get the signature of the plaintiff. Then you need to mention the name of the counsel. Then comes the verification clause. This is also important. If in case you say that you have made the verification and signed it, you are bound by this verification clause. And if it is found that you have made wrong statement before the court, you can be booked under perjury under section 340 of CRPC. And the magistrate and the court can order for lodging an FIR under section 195 of IPC against you. So verification clause is very necessary. And you need to see that you need to tell your client that these are the things which are mentioned by you. The verification clause should be like this, that verified at the place where you are filing the suit on this day, the date of the month and the year, that the facts and circumstances mentioned in paragraph 1 to 3, like in the above illustration, the paragraph 1 to 3 are the facts of the case. So these are true and correct as per the knowledge of the plaintiff. However, the paragraph number 4 to 7 and prayer clause are true and correct as per the legal advice given to him by his counsel. So you need to see that what are the facts which are true and correct as per the knowledge of the plaintiff, and you also need to see that what are the facts which are as per the legal advice, because legal paragraphs cannot be in the knowledge of the plaintiff. If it would have been in the knowledge of the plaintiff, he will never come to the advocate. So you need to clearly define that what are the facts which are in the true knowledge of the plaintiff and what are the facts which are as per the legal advice given by the advocate. Then you need to get it signed by the plaintiff. After you draft the suit, after drafting of the suit comes the institution of the suit. Institution of suit is defined under section 26 and order 4 of CPC. It says that the suit should be the plaint should be filed along with a Xerox copy of that particular plaint. If in case you do not file the Xerox copy, it is liable to be rejected as per order 7 rule 11 of CPC. So the institution of suit basically is that every suit, so you need to see that the Xerox copy or the complete set of the plaint is an extra copy is given to the filing counter, and your suit is instituted as per section 26 and order 4 of CPC. It says that every section order 4 of CPC says that every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. This particular thing was added in CPC after an amendment in 1999. Before that, this particular provision was not there in CPC. So you need to see that you file the duplicate copy with the court. Every plaint shall comply with the rules of order 6 and 7. you need to see that all the rules mentioned in Order 6 and 7 are complied with. That it mentions the name of the parties, it mentions the description of the plaintiff and the defendant, it mentions the description, the brief facts of the case, it mentions the cause of action, the limitation, the court fees, and the prayer clause. It should also mention the verification as per Order 7 Rule 14 of CPC. After the suit is instituted, comes when the plaint is filed, the suit is comes before the court. The court issues a notice as per Order 5 of CPC that the defendant has to come appear before this honorable court on this particular date, and the defendant has to, after receiving the notice, the defendant has to file his written statement within 30 days, which can be extended up to 120 days with proper cause given by the defendant. If in case he doesn't give a proper cause and he says that he was not able to file it within the 120 period of 120 days, then the court will struck off his defense and proceed the case ex parte. And if in case he files the case as written statement within 30 days, the suit will be proceeded as per the provisions of CPC. And after the written statement, the plaintiff is also given an opportunity to file a replication. The replication basically is that how you what are the defense, what are the rebuttal which you have on the defense which was taken by the defendant in his written statement. After this replication is done with, the pleadings are complete. The pleadings which are defined under Order 6 are complete after plaint, written statement, and replication. The defendant doesn't get an opportunity to file a replication. He doesn't have that opportunity in the provided under the CPC. After the pleadings are complete, the court asks for the affidavit of admission and denial. Admission and denial basically is that what are the documents which are admitted by either of the document filed or relied upon by either of the parties, what are the documents which are admitted by either of the parties, and what are the documents which are denied. This has to be done by way of affidavit. The plaintiff files the affidavit that the document filed by the plaintiff, by the defendant, are either admitted, that this particular document are either admitted or this particular document are denied. He also has to mention the reason as to why he is denying this particular document. It either can be that this is a Xerox copy, the original is not there. It can either be that it is a document in the electronic form. It can either be that this is a document which has been framed and it has never been come into the light of the, was not filed with the pleading, and he has filed it at a later stage. It can be, it depends upon the case to case. This also has to be done by the defendant. The defendant also either admits or denies the document filed by the plaintiff. And in case he admits a particular fact, then the plaintiff can file an application under Order 12 Rule 6 that, Your Honor, the defendant has admitted to this fact, and Your Honor may pass a judgment, this honorable court may pass a judgment on the ground of admission of the defendant that this particular fact has been admitted, and my suit is now doesn't need any evidence, and judgment be passed summarily by the court, by this honorable court. So if in case the court finds that the admission is very well made out, the court can pass the judgment by passing the appropriate order and by passing a reason, an order with proper reasons that I am passing this judgment summarily because defendant has admitted to this fact, and this case doesn't need any evidence or oral evidence now, so a judgment can be passed. After this stage is over, the court frames issues. Issues would be that, like in case there is the defendant raises an issue that this particular court doesn't have a jurisdiction, or this particular suit is not within the period of limitation, and plaintiff has filed the suit that the defendant is liable to pay me such amount, is has fraudulently done certain thing, or whatever the case may be. So the court will frame issues that whether the suit is within the jurisdiction of this honorable court, and he will in brackets write OPD, uh, which means that onus of proof is on defendant. Onus of proof is very important, that the defense is, this particular defense is being raised by the defendant, that this particular court doesn't have the jurisdiction. So the defendant has to prove that how this particular court doesn't have the jurisdiction. The defendant raises a ground that this particular court this particular suit is not within the period of limitation. So the issue will be that whether the suit is within the period of jurisdiction, limitation or not. So within bracket, it will be written OPD. OPD again means onus of proof on defendant. Then the issue will be whether the plaintiff is entitled for the relief. It will be written OPP. Onus of proof is on plaintiff. Now the plaintiff is asking for his for the particular relief. So it is a duty of the plaintiff to prove that this particular fact is with the evidence that this particular fact is there, and he is eligible for this particular relief. So the issue, whenever the issues are framed, the court writes in front of that issue OPD, OPP, OPD. So if in case you come up with a file and you see during your internship or whenever you start practicing and you get confused that what is this OPP and OPD. So OPP means onus of proof is on plaintiff, and OPD means onus of proof is on defendant, which means that the defendant has to prove that particular fact, or when the onus of proof is on plaintiff, the plaintiff has to prove that particular fact. After the issues are framed, the trial begins. Whenever a question comes to you or your professor, or in case you go for any competitive exam, and it is asked that when a trial is started in a civil suit or when a trial is started in a criminal suit. So in a civil suit, the trial begins when after the framing of issues. Before that, the trial doesn't begin. It is just that the court is following the procedure, but the trial begins after the framing of issues. And likewise in criminal case, after the framing of charges in a warrant trial and after the framing of notice in a summary trial, the trial begins. Before that, the trial doesn't begin. It is the procedure which is being followed. The trial begins after this particular stage has arrived and gone. After the issues are framed, the trial begins in a civil suit. And it means that you need that both the parties are given opportunity to produce their evidence before the court of law, that based on these particular evidence, we are going to prove that the plaintiff is going to prove that he is eligible for the relief, and the defendant is going to prove that he is not liable for that particular civil wrong which is being filed against him. So firstly, the plaintiff is given an opportunity to file his evidence as per by way of an affidavit. He files an affidavit by way of evidence, and before that he has to file the list of witnesses also. List of witnesses has to be filed within 15 days from the date of framing of issues. If in case the plaintiff or either of the parties doesn't file that particular thing, their right can be closed by the court as per their discretion. In case the court wants to allow them to file the list of witnesses beyond the period of 15 days, it depends upon the discretion of the court. After the list of witnesses, the plaintiff will examine the witnesses which he wants to examine. It can be the witnesses who needs to produce official records, like the case belongs to a particular partition. So the plaintiff will summon the revenue record from that particular place where the property is situated, and the revenue estate is there, and the plaintiff will write that in the list of witnesses, office bearer or the clerk from the revenue office of that particular place, whichever the case may be. In case he has to summon certain record from a particular case, then he will summon the element of that particular court, and likewise. After the exam, when the evidence is produced by the plaintiff, the defendant has the right to cross-examine the plaintiff's witnesses. And during the cross-examination, he can shatter the case of the plaintiff. Whatever he is saying, he can he can ask questions which will damage the case or damage the facts which are being said by him and are contradicted during the cross-examination, that will particularly help the defendant. After the plaintiff witness is over, the defendant gets the right to lead his witness, and he will also he also got the opportunity to file the evidence by way of evidence, and the plaintiff's counsel now gets the opportunity to cross-examine him. And after this examinations are complete, the stage to do final arguments comes into question. The plaintiff and defendant will get an opportunity to raise their final arguments that Your Honor, depending upon these particular facts and depending upon the cross-examination, depending upon the evidence I am relying upon, the relief should be given to me. The defendant will argue that depending upon the examination of the plaintiff, depending upon the statements made by the plaintiff, depending upon the admission made by the plaintiff, the suit should be dismissed. After the final arguments are heard, the court will reserve the order and reserve the judgment, and he will pass a judgment after he has to pass the judgment within 30 days from the date of reserving the order. He can extend it, but as per statutory provision, he has to pass it within 30 days. In certain cases, the judge passes preliminary decree before passing the final decree and judgment. So preliminary decree are passed in cases where there is a suit for partition and the share of the plaintiff or the properties are not properly defined, or like in case there is a partnership firm and the partners are parting ways and the rendition of account has to be done. So during that particular suit, the court will pass a preliminary decree that this is a share of both the parties, but the share has to be defined, the rendition of account has to be done, or the property has to be taken into consideration, that what are the properties of the partnership firm, which has to be divided accordingly. So when the preliminary decree is filed, either of the parties can pass an application, can file an application for appointment of receiver. The receiver will be a person appointed by the court who will determine the share of both the parties, and what all are the properties which belongs to partnership firm, like in case of partnership firm, or what are the properties in case of a partition suit, that the legal heirs are entitled to this particular share in these particular property, and what are the movable properties which can be divided as per the share given in the preliminary decree. And after the receiver's report is filed, the court will pass the final decree. The final decree will be the judgment and the decree of the court, which can be challenged by either of the parties before the higher court. So, coming to the crux of these things, after the filing of the suit, these particular procedures are followed till the judgment and decree is passed. So in case any of the procedure is not followed by the court properly, this becomes a ground for either of the party to challenge it before the higher court, or to file any interlocutory application before a higher court that the miscarriage of justice has been done by this particular court and he has not followed this particular procedure. So from institution of suit to judgment, passing of judgment and decree, these are the procedures which are followed in the court of law when a civil matter is filed. These are defined under the CPC. So I will conclude this class and would like to have questions from the students, if in case they have.
Thank you, sir. The class is open for questions. If you have, you all may raise, if any. Anyone has anything to ask? Yes, Sahaj.
Sir, my question is regarding, sir, when there are more than two parties in a suit and they file suit at their places, so in those cases, what will happen? That the case will get joined, or
See, Sahaj, in case there are more than two defendants, the suit has to be filed at one particular place. In case there is a dispute between the dispute is between A, B, and C. The A will file a suit before a particular court where the place of jurisdiction lies, and if in case B and C are residing at a different places, he will file it in either of those courts. So you cannot file a case in Bhopal and in Delhi on same particular issue against same particular parties. So one suit will be stayed by the court when this particular fact will come into picture, that this particular suit between the same parties on the same issue is pending before a particular court, and this party has again filed the suit on this particular issue before this court also. So this suit should be stayed because that particular suit was filed earlier. So whichever suit was filed earlier will go on, and the suit which is filed later on will be stayed by the court whenever this fact will come into the picture.
thank you, sir.
Yes, is there any other question? Is there somebody has to ask anything? Yes. So we can conclude, sir. And
yes, we can.
We are very thankful to Akshay sir for just giving us the insight from the institution of a suit, that is from the plaint, discussing the plaint, and thereon from how does the plaint continues, then service of summons, then preliminary decree, then admission denial, issue framing, and so till judgment and even till appeal. So I believe that the session taken by sir will be helping us during our classes with respect to the entire aspect of CPC, the entire procedure from the institution of suit till the judgment itself. Thank you, sir, and for giving your time. And I hope, sir, soon we'll be having, we may have some few lectures more if the class wishes to. Okay.
Thank you. Thank you.
Thank you, sir.
I'll be glad to take another session. Thank you.